So I'll just dive right into this about who we are and kind of paint you a picture about how you can picture from your perspective, your world, how we might be able to help you if we can do that. So within the Department of Labor, in our Division of Workers' Comp, we're Jefferson City based, and our unit is called the Fraud Non-Compliance Unit. We've been around since 1993, created by statute. Our sole purpose for existing is found in Chapter 287 of state statute that focuses on Missouri workers' comp law. And so we have some authority, my unit does, related to that, just regarding us promoting the integrity of the law and helping employers, businesses, and employees. And our main goal, just ensuring that employees get the benefits that they're entitled to. So that's that in a nutshell. So you've just been introduced to a couple of our folks that have come down here this morning. There are 10 investigators assigned to the unit. So besides Ed in St. Louis, we have another field one that's in Kansas City. Probably would make sense to you that just the way Missouri's laid out in the two big metro areas, a lot of the volume of our work comes from those areas. So we have positions in those areas. Everybody else is Jefferson City based and out of our office. So besides those 10 investigators, there's little old me and 2 support staff there in the office as well. So that's who the unit is, and I'll tell you a little bit about what it looks like from there. So I do want to explain this. Heather was just asking me, do you get a chance to speak to audiences like yourselves? And from our perspective, not enough, and we really want to more often, and we've really created a focus to do this in this last year or two. So I just want to lay out to you and maybe give you a picture of how we might be able to help you. This is our vision statement for our unit specifically here. So we are an investigative unit. That's why we were created. So obviously investigations are a big part of who we are and what we do. The makeup of our unit, I mentioned 10 investigators and 3 additional staff. I'll tell you that we probably are a majority of former law enforcement with that experience. And we stole Courtney, for instance, from social services, but she has prior law enforcement. And we stole Ed and Wes from our sister division within the Department of Labor, the larger one, employment security, works with unemployment, et cetera. So that's our makeup, generally speaking. That's who we are, and that's a lot of what we do. But we also, in our vision, is prevention, and that's what I look at an opportunity like this. So you'll hear me say this a couple times probably this morning, but I want to say it now so we squeeze it in, is please contact us. We will talk to anybody, anywhere, anytime with information like this to your organizations, to your associations, to your businesses. Does not matter how big or small or where you're located. We'll come to you because we would much rather be in a prevention mode than sort of an investigative mode. Because I just mentioned a lot of us are former law enforcement and we are then naturally lazy. So we would rather be doing this, right? So that's kind of who we are and what we're about, but also service. And what thing I've really, 30 years in law enforcement, one thing I've enjoyed about this position is I do feel like when you come to work and during the course of the week, we do help people, and that's a really good feeling. So service is a big part of what we do. So even though we say we've opened up a case or we're conducting an investigation, the majority of that, as far as our service, then we find ourselves, we believe, helping employers and employees at least get on track. So that's who we are trying to be and what we're all about. Okay, so what you may want to know, and I want to explain a little bit about how to contact us, is first and foremost, and again, once again, a lot of former law enforcement, we are by nature lazy, so it sure helps us, and I think we can help you more if you have any questions, any doubts, any concerns, complaints, allegations. Please contact us, number one, and I want to explain to you how to do that if you don't know already, but also contact us early, because even if there's a doubt in your mind or a lot of ifs, contact us, because we'll let you know, yeah, we can help. We'll give this a shot. We'll look into this for you. So contact us and contact us early. That's our main message here this morning when we get together and meet nice folks like you. So how do you get a hold of us? How do you report? Okay, so we work for the state of Missouri, and we probably don't have the quality IT people like Connell has, and you know, most private industries. So For instance, our email address, one way to get hold of us, efficient way, but you'll notice, I don't know why I can't say fraud and non-compliance, wouldn't that be easy to remember? But you can contact us at fraud and non-compliant at that address, and that's a good way to get hold of us, efficient way. We have the toll-free number, and that's still a very popular way to get a hold of us, and we get to answer any questions. And then, of course, we still get a lot of inquiries through snail mail, through land mail, and we respond to that as well. So any one of those methods, just general inquiries and those numbers, contact us. There's our fax number. So I don't know. It doesn't look like you've got a packet of information for us, but if you want to jot down any of this contact information, this is probably the more efficient ways to get a hold of us. Okay, so also a main message that I want to share with you, and this isn't just because Kurt thinks it's a good idea. It is in state statute. Any person can make a report, bring an allegation, report a complaint to our unit. And we do. That's how we get information. So I want to reinforce that. Again, if there's any doubts or hesitation about how to report or who should report, any questions or problems regarding workers' comp law, then have no doubt, just call us, because any person can do that. Talking about the makeup of our unit, so just give you an idea, most recently in 2018, our crew worked 421 investigations. We were in 70 counties throughout the state, plus the city of St. Louis. So have a presence around the state. There's no one single focus, obviously. And I did mention that just because Ed's in St. Louis and we have Misty in Kansas City, yeah, they pick up a lot of business there, but we are not established to work regionally by any means. So our investigators scatter all over the state when they get assigned cases to help folks. And just give you a breakdown. This will make a little more sense to you here in a little bit when Dwight speaks to you about what we do. But as far as the percentage of types of cases we see in our unit, last year, you can see it's a relative balance between us investigating alleged fraud, complaints of fraud involved with workers' comp, and we'll define these two for you, fraud and non-compliance, but a mix of non-compliance cases and those types of cases where we're inquiring on is if employers are establishing the liability protection that they're supposed to have by law. So we'll define all that to you here in a second, but I'll give you an idea of, once again, our workload here. So who does report to us? Well, that gives you a little bit of breakdown from 2018, just to give you an idea. So I understand a lot of HR professionals here, safety folks in this audience, I think, and I know there's probably some more folks. Just give you an idea who we hear from, how we get reports and cases to our office, generally speaking. Most recently in 18, you can see about 9% came from law firms, from attorneys, and then employers were just 2%, employees almost 20%, and insurers, good partners of ours, about a quarter of our caseload, healthcare professionals, but pretty large majority, isn't it, of anonymous. And so make no mistake, when I say any person can report, anybody does report, and they don't, and we investigate it. We'll make inquiries, we'll look at it. So that's not, doesn't have any significance to us. We're still going to look into it. Also good partners for us as far as how we receive these types of reports also comes from our sister division within the Department of Labor on the other side of town in Jeff City, and that's the Division of Employment Security. They'll send over reports and information inquiries to us that we take a peek at and take a look and see if we can help. The Department of Insurance, and in fact also when it says FNU, that's our unit, inquiries, we also, we have a focus of trying to take a peek at, we'll look at data-driven information where we think we ought to make inquiries, if there's trends, et cetera, how, where employees are getting injured, and just making sure if we can help along those lines. So that's how many of our cases are created. Okay, so when a report is made, I want to explain a little bit about our workflow at our office, just to paint you a picture. If you go through the trouble of calling us and seeing if we can help you, just give you an idea how this works. It's not really complicated, but I want to explain it to you so you have an idea, so you don't think, well, you know, I don't know what's going to happen with this call or this inquiry of mine. So I'll get that on my desk. We'll get the initial report, however it was received, and I talked about how we might get a report received in our office, and then I'll get that case assigned. And so when I say I review a report, I've only been there a couple years, but I'll tell you, I've only rejected one report that we didn't inquire report, and that's just because it was just a random letter, anti-government, angry about a lot of things, and wasn't really anything I was agreeing with a lot of the stuff in it, but I wasn't, wasn't anything we could do about it. So, but that's the only one I can remember saying, no, we're not going to stick our nose in this business here. So, but regardless, that's how we receive that, and that's the first stop there. Then what I do is I'll forward that to one of our team supervisors, who I just introduced, Calvin or Dwight, and say, hey, would you take a look at this and assign this to one of our team's investigators for an inquiry, for an investigation here. Then Dwight or Calvin will turn around, give it to our support staff, assign it in our case management system, assign a case number, and then we're off and running. Then the real work gets done by Courtney and Wes and Ed, for instance. They get assigned the case, and they'll start their investigation. This is probably something you're more interested in with this workflow. So the investigator will then obviously conduct an investigation. They will create one report. And it can, depending on the case, one large report, one small report, but they'll create one report. And from that report, the investigator, what they're doing is they will submit that and kind of return it in the backflow of the workflow with a recommendation. And they'll say, as a result of my investigation, I can't substantiate there's any violation here, and or it looks like the employer got themselves on track, or I helped them get on track, or the employee, the issue was resolved, or there's a problem, or I have probable cause that I believe I have probable cause that there might be a violation of law. And that's what Dwight's going to get into a little bit about details for you on that. And then if that's the case, it comes back and then make its way back to my desk, and I'll take a peek at it and agree with the recommendation eventually, or disagree with it. We'll do some more work, whatever we do there. And then beyond that, what happens, and what I want to mention about this one report that I'm talking about that an investigator will generate is that, and this is kind of a hitch, it can be frustrating for you, can be frustrating for us. Again, this isn't just because that's the way we wanted our unit. This is in state statute. These reports are completely confidential. There's obviously good reason for that. And the only hitch to that is if you contact us and you identify yourself and say, hey, we've got this problem, can you help? Yes, we can. We'll dive into it. But we can't share much about the investigation of anything. Now, not to say so, you probably from your desk, you might say, hey, can I get a copy of your report, as a result of this? And no, you can't, because it's state law. We can't give that to you. But that is not to say that you won't have a relationship established with the investigator that you can be talking for updates, things like that. So, but I wanted to clarify that. So when our cases get closed internally here, so if the recommendation from our investigator is to close the case, there's no probable cause, there's no violation, and or we've got everybody on the right track and everything's good. We always like to hear that. Okay, great. Then we close it internally, and then eventually that report's just going to go into archives after about 6 months. However, cases that are recommended with a referral for a potential prosecution where we believe we have probable cause that there might be a violation of state law, why then we'll submit that down to our boss, the division director. And again, not because that's our protocol, but because state law says it's the division director that will make the recommendation, the final recommendation, if something's going to go forward for prosecution, for potential prosecution. And then to give you a picture of what that's about, and I don't know if anybody's had experience to this extent, but these referrals, once they go to the division director, we've got a really great relationship now. We didn't always have this, but matter of fact, as of very recently, these last couple months, all our cases in every county in the state, above a certain penalty phase of $3,000, but all our cases that are criminal violations, the Attorney General handles prosecution for that. So that's a good thing for all of us. That's a win for all of us, because in the past, this unit would have to go shop for a prosecution with the local prosecutor in the county. Not that that's they're incapable of doing it, but you all might have be able to visualize a picture. Our county prosecutors are very busy people. They have, they're working murders and rapes and bad stuff, and you know, this would be really higher on their priority versus our cases specifically go to the labor division of the Attorney General's office for their staff of attorneys. So if something needs to move forward in court, they'll move it forward. So it's a really good focus. So it's really a win for everybody here in Missouri that we have that relationship now. So that's where that's going to go if and when a case is determined that we think we have probable cause that there's been a violation and needs to move forward in the courts. So I think with that, I'm going to turn this mic over to Dwight, and he's going to, yeah, but we're going to do it anyway. And he's going to visit with you a little bit. I rattled on about what we're about, but he's going to get a little more specific about what the law says and questions you might have about that. Thanks, Dwight.
Okay, so again, my name is Dwight Mueller. I'm Investigator 3. I'm one of the supervisors in the unit. And I'm going to do the next few slides here before I turn it over to Calvin. So what does a FNU investigate, Fraud Non-Compliance Unit? So our the main thing that we investigate is probably is non-compliance, and that is the employers not ensuring their liability according to statute or as they're required by law. One of the other major investigations that we look at is failure to report an injury. That's your responsibility or the responsibility of an employer. So I want to just say a little something about that because we deal with this every day, and you know, I deal with employers every day, and they say, well, I didn't know I was supposed to report that. So basically, if an employee comes to the employer, that could be a supervisor, the president, whoever, and says, I was injured at work, you are responsible and required to make that report. Whether you believe it or not, that's to be determined later, okay? If they come to you and say, I got hurt at work, you better start getting the report made, get it to your insurance company so it can be reported to the division, and then you won't be seeing us about a failure to report violation, okay, or the employer won't. We have employers in here, is that right? Everybody's pretty much employers? Okay, thank you. One of the other things that we do is fictitious certificates of insurance. People get insurance, they get a certificate, they get canceled because they don't pay, whatever, and then someone asks them for a certificate. They pass that, they maybe alter the dates on it, whatever. We do quite a few of those. As far as the employees, fraudulent injury claims, denying prior injuries, sometimes that's kind of sticky. You know, I don't remember every injury I've had. Most people don't, unless it's a significant injury. But here's some of the other things that we work with. Lying to an employer, giving false information, medical providers, that kind of thing. And all these are related to acquiring or interfering with a claim or a benefit to an employee. Sorry. So what is the statute of limitations? So almost everything we work on is a 3-year statute of limitations as from the date of discovery. The only thing that is different is the failure to report, make the 380 violation. It's a 13-month statute. The employer has 30 days to make the report, and then an additional 12 months for our statute. Some of the other violations, these violations are misdemeanors for a first-time offense. And how we resolve these violations are, some of them are with a significant fine or a penalty, and others are through a deferred prosecution agreement, and that is with the Missouri Attorney General's office, the Labor Division, who prosecutes our cases. That's all of their business there, but that's kind of how we resolve these violations through prosecution. Keep in mind that the Missouri, or the workers' comp law is a violation of law. If you don't insure your liability and someone gets hurt, you're in violation of the law, so you might see us. And hopefully that doesn't happen, but and then we make sure, or help make sure, that the employee receives their benefits they're entitled, and put businesses on a level playing field. Just as an example, construction companies, if a lot of bidding goes on to get jobs for construction, if one business is bidding and they've insured their liability, and another business is bidding that they haven't, who do you think is going to be able to make the cheapest bid? The one without the work comp liability. So, and we hear that a lot from construction folks. Well, I'm just trying to make a living out here, but I can't because you know, I'm trying to do everything by the book, insure my liability, whatever. And Joe Blow down the street here gets all the bids because he don't have that work comp overhead. So we're just trying to level the playing field for employers and getting the benefits for employees that they deserve. So who's affected by the work comp statute? Everybody. Everybody in this state is. Employers, employees, everybody's subject to the work comp statute. There are a few exemptions, and you can see them up on the screen there. Farm labor is one of them. If you are a farm worker or you own a farm, you hire labor, you're exempt. Domestic servants, you can see who those folks are. Volunteers of tax-exempt organizations, and some religious organizations. The Mennonites, the Amish, to name a few, are all exempt from the work comp statute. Now, they have to file an exemption with a division in order to get that exemption, though, okay? So we verify employment and claims through the Division of Employment Security, which Kurt talked about moments ago, and through our own databases that we have at the Division of Workers' Comp. So every time that a insurance policy is either issued in Missouri, it's canceled in Missouri, or renewed, the insurance provider has to provide a memo to the division. So you can imagine what kind of work they do, but it's required that they provide that memo. And then we use NCCI, that's the National Council on Compensation Insurance, thank you, Calvin, to verify work comp for employers. So we get an employer's name, we get a complaint, we get their name, we can go right on my computer on my desk, type in their names, see if within just a few minutes if they've insured their liability or not. So what's non-compliance? Kurt said I'd explain that here, so here we go. Pretty simple. Failure to insure your liability, your workers' comp liability. Every employer is required, and I'm going to get into the exact requirements here in just a second. But failure to insure your workers' comp liability puts employers at risk, and they don't get the benefit they're entitled to, and then employers are exposed to liability risk, and you know, it's just a safety net. I tell employers every day, you know, it's a safety net for you. Just as an example, if you have an employee that gets hurt, you don't have the coverage, who do you think is going to cover that? Who do you think is going to cover that injury? You as the employer are still going to cover it because you're going to get sued civilly, and you're going to lose, and you're going to end up paying. So I want to give you just a real quick example of a case we worked many years ago, and just put a thought in your head for a second how important and serious this is. So I worked a case in Kansas City. It was a construction company, concrete. They poured concrete. They had an employee that was, they had poured a little bit of concrete, some walls and stuff. They weren't very tall, 5 feet. They had an employee that was standing on one of those walls, and they were using a boom truck that day. Everybody know what a boom truck is? Has this big old thing that pumps the concrete from way over there to way over there. They were moving this boom along to get ready to make a pour. The boom accidentally hit the employee that was standing on the wall. The wall was 5 feet tall. He fell on some concrete, had a moderate injury, moderate to severe injury, head. So last time I heard that medical for that, let me back up, the employer was not insured. The last time I heard, the medical for that injury was in excess of $1.5 million. Just the medical, okay? So, you know, most businesses, or I've dealt with a lot of businesses and I don't see it. Most businesses couldn't handle a $1.5 million debt like that. So it's a safety net. If someone does get hurt, one of your employees gets hurt, you have that, the insurance to get them covered, okay? So that's just a little thought, you know, how serious this can really get in a big hurry, okay? And again, just keep in mind that it's against the law there. An employer is defined as every person, partnership, corporation, LLC, LLP, that's using the service of another for pay. So they're paying someone, they're an employee. And this is where I'm going to get a little more specific, who is actually required by statute. If you're an employer in Missouri and you have 5 or more employees, you are required to, to insure your liability. Unless you are a construction company, and then it's 1 or more. So 5 or more, 1 or more. And when we go into a business and start counting employees, family members count, all your brothers, sisters, mother, dad, all that, cousins, everything. And all part-time, seasonal people, they all count. So unless, if they're there, they're probably going to count, unless you can provide information otherwise. An employee is described as a person in the service of an employer for pay. And here's, whether it's a contract for hire, express, implied, oral, or written, whatever. If you're getting paid by someone, you're their employee. Some of the issues that we deal with daily is, when we're looking at investigations and trying to determine if these people are employees or subcontract people, subcontract workers. We work with misclassified employees because for some reason some people just can't get it straight, but the majority that we work with is the subcontractors and employees versus employees rather. And I go to businesses all over the state. Went to one yesterday coming down. Calvin and I was driving down. We stopped to work a case. And the guy we talked to said, well, he's a contract worker. Well, what makes him a contract worker? Well, he's got his own tools. Okay, well, that's not exactly right. But the difference between an independent contractor or subcontractor and an employee is the amount of control you have over that person. So if you have control, they are an employee. If you tell them they got to be to work at 8 o'clock, they're taking a break at 10 to 10:15, go to lunch at noon, come back at 1, blah, 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 on and on, that's control. You tell them what they're going to do, how to do their job, that's an employee. Most subcontractors, not all the time, but most of them, have their own business, heating and air, all those refrigeration, all those kinds of things. So when you hire those people, You don't have to tell them what to do. They already know what to do. All you got to do is say, hey, I got an air conditioner over here that needs worked on or it needs installed, whatever. There it is. Have at it. Okay? You don't care how long it takes them. They can come to work today, work an hour, go home. Come tomorrow, work 30 minutes, go home. As long as they get the job done in your required time parameters, and you don't care about that, then we're talking about a real subcontractor. So when we go in to start counting employees, the first people we count, or we start counting with, or the first people I start counting, are all the corporate officers, the LLC members, all those kinds of folks first. So we have a corporation that has president, vice president, secretary, treasurer. They already have 4 employees. We have an LLC that has 2 members. They already have 2 employees. And then I count everybody after that. Again, it's 5 or more, 2 or 1 or more. And the next bit there, if you are a business, a corporation with 2 owners and no employees, it says there you don't count, which you don't, but you have to have an exemption from the division for that to work, okay? You call the division and inquire about getting a corporate exemption. They fill that out pretty quick, it's done, and then that statement there is true. Sole proprietors, partnerships do not count as employees. So if you, excuse me, if you have a business, you're a sole proprietor and you have 3 or 4 employees, that's how many employees you have. And then we verify all business registrations through the Secretary of State. We have that database on our access to that database, and we verify that through the Secretary of State's office. I think that's all I'm going to do here. I'm going to turn the last several slides over to Calvin here.
What is fraud? We're going to get to that because Dwight talked a little bit about failure to report, and I want to make one clarification. The only requirement for an employer to file a first report of injury with the division is when the employee seeks medical care beyond first aid. Okay? So if they go to a doctor of any kind, doesn't matter, dentist, chiropractor, medical physician, and you become aware of that, whether you send them to seek medical care or they come back in on a Monday or a Tuesday after a long weekend and say, hey, remember Friday when I was at work, I slipped and fell, I got hurt and went to the doctor? Then at that point you need to notify your insurance carrier of the injury, okay? If they never seek medical care, you're not required to report it. There's a provision in the chapter that says that an injured worker could lose his or her right to receive benefits if they don't do certain things. And the law says that they have to report the injury to you in writing. There is an exception to that, though. And that exception is if you as an employer are not prejudiced by the knowledge, meaning if you watch the person fall down and get hurt, you have knowledge. If you instruct the injured worker to go get medical care, you have knowledge. They're no longer required to put that in writing, okay? All right, so let's see, what's the next slide? Certificates of insurance. You know, I'll talk about that too. Let's just go into fraud. How's that? Because that's what you really want to know about. And that's my bread and butter. So what is fraud? That slide kind of gives you a legal definition, and I'm going to summarize it for you really simply. It's a lie. It's a lie that is material to the person obtaining a benefit. It's a lie that is material to the person denying a benefit. Employers can be charged with violating Missouri law by making a false or fraudulent statement to deny a benefit. Let me give you some real quick examples. You have a workers' compensation insurance policy, and you have a person who's injured at work, and they come to you and they say, hey, I was hurt at work and I need your workers' comp information, and you say, I don't have workers' compensation. Well, you've made a false statement. And the only reason why you would make, in my mind, the only reason why you would make that statement is because you don't want them to file a claim against your workers' compensation insurance carrier because you're afraid that your premium might go up, right? Well, you've just committed a crime. It's a Class A misdemeanor, which is punishable by up to 1 year in jail. And the penalty, and we have a kind of a unique set of statutes, because under most criminal cases, there is no penalty to the person who commits the crime, but in ours there is. And those penalties can be significant, and what it says is it's double the value of the fraud, or $50,000, whichever is greater. Okay? So if that injured worker obtains $1 million in medical care, you're going to probably be in a lot of trouble. So when we talk about fraud, we have to talk, when we talk about a lie, we have to talk about its materiality. It's not just any lie, okay? We see this a lot with depositions. So a person gets injured at work, they file a claim, the insurance company wants to defend that claim. The person runs out real quick, they get an attorney to represent them, and the insurance company is never able to talk to them until they get to the deposition phase. And when they get in that deposition phase, after all depositions are discovery, they go through medical records and they go through the injured worker's past, and they see that the person had a back strain maybe in 2013. And here we are in 2019, and the question is, have you ever injured your back before? And the person says, no. Insurance companies are very quick to say, aha, I got you, that's a lie. Is it? You have to look at the totality of the question and the circumstances. I'm 50 years old. I spent 12 years of my life jumping out of airplanes. I have hurt just about every part of my body. I have strained my back. But if you were to ask me if I ever injured my back, I might say no. Because I'm not thinking about straining muscles in my back or injuring myself. I'm thinking, when you're asking me this question, have I ever broke my back? Have I ever had a bulging disc? Have I been laid up because I couldn't, for something I did? So that's where we come in. We will look at the medical records. We will interview the suspect. We'll talk to doctors. We'll talk to friends and neighbors. Ex-wives and husbands are a great source of information for us. And we actually have 2 cases right now that came to us by ex-spouses. One of them, this is great because we're going to look at her for conspiracy to commit fraud. She tells us after the fact, after the settlement was done, that he wasn't hurt at work. And what she's really mad about is she didn't get any of that settlement money. So I can't wait to be the guy that breaks it to her and says, you knew about this all along and you didn't say anything, and you went along and you went to the doctor's appointments and you showed up at that deposition. That's conspiracy to commit fraud. So going back to that, it's a lie. One of the things that we see in insurance claims, when insurance companies are involved, is the question comes up, my guy or gal is working. They've been off work for several months. We're paying them a temporary total disability benefit. They're not getting any better, so we put a surveillance team on them, and that surveillance team caught them working. And we just had this case, and we really made one insurance company very upset with us, and too bad it's their fault, and here's why. Because the person was injured in 2013. They didn't bother to report their suspicions until 2018. You guys are going to love this. So December, I think it was, not too long ago, no, it was November of 2018, they have their aha moment. But what they did is they decided they were going to settle the case out of court with the injured worker. So the insurance company's defense attorney forwarded the settlement agreement to the injured worker's attorney, and for her to sign and then give to the administrative law judge to be approved. Now, once a claim in Missouri is settled by stipulation for compromise settlement agreement, we're out. It's over. There's nothing that we can do about it. So he faxes it over to her, and then about 10, 20 minutes later, he calls and says, hey, I want to withdraw that because we've got some new information that says that he's working. We want to withdraw it. The defense attorney, the injured workers attorney, is smarter than this particular attorney and played the game of, I'm not answering your phone. She probably knew something was going on, proving it's going to be difficult. So she doesn't answer the phone call. Instead, she takes the stipulation to the judge signs off on it, it's done. The insurance company finds out and they go ballistic because they've been dragging this on since 2013. They've spent a lot of time, effort, and money. Surveillance is not cheap. It's cheap for you if we do it. So if you have a surveillance need, contact us. As Kurt said, contact us early. We're all trained in surveillance and counter surveillance, and we will go out there and we will do that surveillance. But oftentimes insurance companies rely on private vendors to do it, and it costs them a lot of money. So it was done. They sent it to us to see if there's anything that we could do. And we went through the case, and what was glaring is that they had their suspicion that this person was working all along, and they were operating under the premise that if he was working and collecting temporary total disability benefits, he was in violation of the law. Well, he's not. You can work in Missouri while collecting TTD benefits. What you can't do is lie about it. So if somebody were to have asked him while he was collecting the benefit, are you working? And if he would have said no, then he would have made a false, fraudulent, and material statement to obtain the benefit of temporary total disability benefits. Nobody asked. Where's the lie? If you don't ask and you don't give them an opportunity to make a statement, whether it is to make a fraudulent statement or to clarify their activities, there's no lie. So that's fraud in a nutshell. With fraud, there has to be a lie. It has to be material to them obtaining or denying a benefit. And it can't just be any lie. Do you guys deal with certificates of insurance? How much time do I have, Kurt? Okay. Do you guys ever deal with certificates of insurance? How many employers are in here or governmental bodies? Okay. It's kind of funny. I'm going to jump ahead and come back to that for a second. No, I guess I'm not. Okay, so the governmental bodies, here's the thing. If you are a city, county, and you issue a business license to a contractor, somebody who's engaged in general construction work, you are required by state law to obtain either an affidavit that the person is exempt from workers' compensation or a certificate of insurance. Missouri law criminalizes altering a certificate of insurance to show that you have a current workers' compensation insurance policy when you don't. And it's a felony. Under current law, that would put somebody in prison for up to 3 years. One of the things that we deal with a lot, and Dwight touched on it, are certificates of insurance, because workers' compensation insurance is very expensive. We don't regulate that. We have nothing to do with that. That's set by the Department of Insurance. All we do is enforce it. Think of us as you would detectives in your local law enforcement agencies. Like Kirk kind of alluded to jokingly, but there's probably a little bit of seriousness there because I can say it. I enforced the laws of the state of Missouri for a long period of time, and I didn't always agree with the laws, but I always did my job. So with the certificates of insurance, or rather with the cost of insurance, that's nothing that we can do about, but what we can do about is preventing people from providing fraudulent certificates of insurance. And why is that a big deal? Dwight said that we came down here last night and we went to talk to a business, and we went to talk to this guy because he owns a roofing company in the area. He is uninsured. I believe he has an employee, certainly non-compliant, because he counts as an employee of his business, as Dwight talked about, but he also provided another company with a certificate of insurance. That company was audited by their workers' compensation insurance carrier, Missouri Employers Mutual Insurance Company. And as a result of that, they discovered that the insurance, that the business did not have insurance. So they charged the general contractor the cost for the insurance for the subcontractor to a tune of $6,000. Why is that a big deal? That's stealing. It's stealing. And that's the way to look at fraud. When you look at workers' comp fraud, it is a white-collar crime, but it's stealing. So that general contractor was out $6,000 on top of what he paid the subcontractor to do the work. Worse, if the subcontractor had an injury, and in Missouri, an injured worker has 2 years from the date in which they allege that they were injured at work to file a claim. So guy falls off a roof 2 years later, should be suspicious for us, files a claim for workers' compensation insurance benefits. His employer doesn't have it. It goes back on to the general contractor. And that's why Missouri Employers Mutual and other insurance companies collect that premium from their insured, because they're the ones that are going to have to defend that claim. I want to have an open invitation to all of you. Dwight touched on it about complaints. We accept anonymous complaints. You can pick up the phone and call me and say, hey, Calvin, you were at the Connell conference, and I got a question for you. And we can have a conversation, and it doesn't need to go anywhere. And I might be able to give you some guidance, some information. You may say, I have a person who I suspect is committing workers' comp fraud. What do I do about it? And I may say, have you asked X, Y, and Z? I'm not telling you to do it. I'm asking you a question. Have you asked X, Y, and Z? And if you have, then we may be talking about, hey, can I get some more information? Let me look into this officially. That said, does anyone have any questions for me that I might be able to answer that might help you with something that you've got going on or a scenario? Yes, sir.
Yeah, this is Bob, City of Branson. So can we still require, as a city entity, can we require a non-construction business that's exempt from having work comp to provide work comp for an activity that they want to do for us?
Yes. Okay. Did everybody hear that question? Okay, the question is, can somebody, I'm just going to generalize it, can somebody, a business, a private person, request that the person that they hire or the business that they hire have workers' compensation insurance even though they may not be required by law to have it? The answer is yes. You can always require it. That is strictly up to you. And my advice is, before I'm going to let somebody get up on my roof, I'm going to have that insurance. And something else that we do is we verify that. So if you hire somebody and they give you a certificate of insurance, and it might look kind of goofy, and I wish I would have brought some with me. The only one I brought with me, unfortunately, I can't show you because it's part of an active investigation. If they look goofy, pick up the phone and call me. Call any of our investigators. All three of those people in the back at one time worked for me, and 2 of them still do. So I guarantee you, if you call them, they're going to look into it for you. And we'll tell you, hey, this is good to go, or no, it's not. And we'll take it from there. Any other questions? Yes, sir. I think the question is, if you as the general require insurance from a sub. Mm-hmm. Okay. You accept that certificate of insurance in good faith that it's valid. That's where we come in. The short answer is, yeah, you could be on the hook for any injuries. But by getting us involved earlier, we are able to conduct that investigation. And if at the conclusion of our investigation we determined that the subcontractor gave you an invalid certificate of insurance, we're in a position for your attorney to defend you by saying, listen, my client accepted this in good faith, because you're not obligated as a general contractor to verify that. I alluded to the cities being required to obtain that information. There's no obligation for cities or counties to verify that information. You just have to get it. So in your scenario, you accept it in good faith, and it turns out that it's an invalid certificate of insurance. There is an injury. Your attorney's, it could be Missouri Employers Mutual. Matt Murphy is going to speak later on, does defense work for them. They're going to enter a defense on your company's behalf, and they're going to say, my client's not liable for this injury. And here's the state of Missouri is prosecuting this business for violating the law, for committing fraud. Yeah. The question is there an easy way to verify that insurance without calling us? I'm going to tell you to call me because I work for you, right? I work for the state of Missouri. You are my employer, and I will answer that question. If you don't want to call me, don't want to have that conversation with me, you can go to the Division of Workers' Compensation's website. I'm going to be honest with you, it's a mess. And we know it's a mess, and we're trying to fix that. I can't find things on there, and I work for the division. That said, you can always look at that certificate and see who the insurance producer is or agent and call them. Now, they're getting clever, and a lot of times that's fake information too. So, does anybody have any other questions? Okay. If you have the opportunity to go to the Workers' Compensation Insurance Conference, it's in May this year, isn't it? It's in May, it's down at the lake. We'll be presenting there. And at that time, we're going to have some more case studies. And I'll really get into talking about specific investigations and giving you scenarios. And I try to get you guys involved and say, what if? This is what's going on. What do you think? And then walking it back and say, yes, that's fraud, and this is why. Or no, that's not, and this is why. So I encourage you to do that. Also, this is a shameless plug. If you would like for us to provide a specific presentation for you all individually, for your employers or whatever, give us a call and we'll be glad to come out there and do it. And we can talk more intimately about specific fraudulent activities and what you guys can do to combat it. But the short version for today, no pun intended, is ask the question. If you think that the person is committing fraud, ask the question. Get your attorney to ask the question. Get the doctor to ask the question. If they make a false statement, let us know, and we'll take over from there. Thank you very much for your time.